Well, you probably heard me this morning. I was a little lit up talking about that issue in the Sun Prairie High School about the 18-year-old biological male that went into a girls' locker room and claimed he was trans and exposed himself in front of four 14-year-old girls. Here's another case of, well, let's just say this is another example of the transdemic that is permeating our society. And here in Wisconsin, I have an attorney with me on the phone from the Wisconsin Institute for Law and Liberty to talk about a situation at Kettle Moraine School District. Luke Berg, good morning. How are you?
Good morning. Thanks so much for having me on the show.
Thank you. I appreciate it very much. I know we've had this conversation before about what happened in the Kettle Moraine School District, but for our listeners that may have forgotten about it or are unaware of it, could you please describe what transpired and what has happened since we last spoke?
Yeah, so first a little background. So a number of school districts in our state, but also around the country really, have decided that minor students can make the choice to change their gender at school and that their parents don't get to be involved or have any say in it. And this is a policy that's been spreading throughout the country. We actually have three active lawsuits in the state currently against the Madison School District, the Kettle Moraine School District, and the Eau Claire School District, each of which have this policy. So our case against the Kettle Moraine School District involves a family who had a daughter who went through this. So she was struggling with some mental health issues, which turned into believing she was a boy and wanting to change her name and pronouns at school. And her parents, after researching it and talking to professionals and thinking about it, decided, we just don't think this is best for you at this time. So they told her no, and they told the school that we expect you to call her by her birth name and female pronouns. And the school basically told them, sorry, too bad. If you send her back here, we're going to call her whatever she wants. We're going to defer to your 12-year-old rather than you as the parents. And so they did what I think any parent would do in that situation. They immediately pulled her from school, started looking for a private school that would respect their decision. And just within a few weeks, their daughter changed her mind and realized that she was wrong, that she was confused, and that all these people around her, all these adults around her, teachers, a few mental health professionals who were rushing to affirm that she was really a boy and push her to transition had actually fueled her confusion. So I'm happy to say now that she's, well-adjusted girl and confident in who she is. But we brought a lawsuit to challenge the district's policy, and they haven't backed down from this policy, but instead have defended it in court. So we're currently before the court, and last Wednesday we had a hearing before a judge to decide who wins the case, basically.
No decision made yet?
No decision yet. We're waiting for a written opinion, but I'm very optimistic that we'll win. The judge had a lot of really good questions. He clearly got the concern. He asked some really interesting hypotheticals of the district's lawyer. He asked about sports decisions. Let's say a student had a really good arm like Aaron Rodgers, I think was the judge's example. But the parents had concerns about concussion risk. Could the school play him anyway because they want to win football games? And the district's lawyer kind of hemmed and hawed, didn't have a good answer to that. And judge also asked about diet. Can the district override parents' decisions about diet? And again, the district's lawyer didn't have a good answer. So I think the judge got it, and I'm optimistic we'll win, but we'll wait and see.
Wow, that's precedent setting then, isn't it, Luke?
Yeah, it will be. There's, like I said, we have three of these cases in the state, but this is happening nationwide, and there are a lot of these cases around the country. I am optimistic that on net these cases will win because I think this is a pretty egregious violation of parents' rights. But all this litigation is still in its early stages, so we don't have a lot of decisions on the merits either way yet. So once you start to get a few, that tends to snowball. So we're really hopeful that we'll get a good decision in this case, and that will start to set a trend of courts around the country recognizing that these types of decisions are the kind of decisions that parents have to make.
Was this family and this particular girl, were they witnesses in this particular case?
They, in a sense, they've submitted written evidence in the
Okay.
case. This wasn't a trial. This was just arguments between the lawyers. It was what's called a summary judgment hearing, where everybody sort of agrees on the facts, what happened in the case, and the judge is going to decide the law, whether this violated parents' rights or not.
So I guess what I'm getting at is that the judge was well aware of this particular individual situation and had an opportunity to, if he wanted to, interact with this family or at least be familiar enough with what happened in their case.
Yeah, yes, exactly. So what happened to this family is the centerpiece of the case, and is an illustration of, I think, why parents have to be involved, right? Everybody at the school was rushing to immediately say yes to this girl, that she could become a boy. She was a boy. And her mom and her dad, her parents, were the only ones who were being cautious about this. And that's part of the point of parents' rights, that parents know and love their children better than anybody else does. They know what's best for their child better than school staff who've been with them for a few months rather than their entire life, right? And so that's why we give parents the primacy in decisions with their children. And that's why the Constitution protects parents' rights to make decisions on behalf of their children. And courts have been very clear that government can't override parents' decisions without a very high evidentiary bar and due process. And none of that was provided here. The school district simply believed that it knew better about how to respond when a child deals with gender identity issues, and said it would defer to a 12-year-old rather than her parents. And that is crazy in my view.
Right.
And I'm hoping the courts recognize that.
So, are we going to need legislation in Wisconsin to require that? Because you did cite, as part of the defense, I guess, the so-called mental health professionals from the school district. Will they be only by law will they be required to, I guess, present both sides of the, I don't know, argument, so that when a student comes to them and is expressing their confusion about their gender identity, that the professional, the adult, must provide them with both sides, so that it isn't just, I guess, I don't know, for lack of a better term, it isn't just so one-sided.
Yeah, that's a really interesting suggestion. I do think there is room for legislation in this area, and I certainly would support legislation that protects parents' rights over this subject. And I think it's important because, as I mentioned, this is happening across the state and around the country. The three school districts that we're suing are not the only three that I'm aware of that have policies like this. What we're asking the courts to hold is that, as a constitutional matter, this decision is so significant. The decision about whether their child changes gender identity is so significant that it's the kind of decision that parents have to make. And so schools have to obtain parental consent before they can begin addressing a child as if they are the opposite sex, in the same way that schools get parental consent for medication at school, or for students to go on field trips or play on sports teams, right? Decisions that are much less significant than changing gender identity. So, if we win those cases, hopefully that will set the policy, at least for some school districts, that parental consent is required. But in the meantime, I would encourage school districts to have their own policy, right? A number of school districts who have heard about our lawsuits have adopted policies to require parental consent for this decision, which I think is a pretty straightforward and should be non-controversial policy. And a number of school districts have adopted it, and that's what I think it should be going forward. So I'm hopeful that anybody listening who is involved in a school board, or is interested in this subject and wants to contact their school board, to do so, because it's really important to have a good policy on this in advance.
And you have some great information on your website with will-law.org/school boards. And I think for any of our listeners that are school board members too, I mean, what a great resource to have. But I mean, I think this is an excellent example of, at the local level, how a school board can be empowered to make that type of policy. And I mean, it really, you make great points. Although I often say that you can't count on common sense anymore, Luke,
Mm.
because I mean, I am hopeful, just as you are, that the judge will rule in favor of common sense. But I guess we'll have to wait and see.
Yeah, the other thing I would add is uh, a number of lawyers and groups have been telling school boards that these policies are required as a matter of federal law, that somehow Title IX non-discrimination law requires school districts to defer to students and ignore parents. That is simply not true. There is nothing in any statute, regulation, not even guidance from even the Obama or Biden administrations that argues that parents must be ignored. So I think that's just misinformation that's been spread by some groups and needs to be corrected. That's an issue that's come up in our case. The district initially defended this as being required by federal law, but then they couldn't actually find anything that said that. So uh, because there isn't anything.
So, what do you anticipate, or I should say, how long do you anticipate this ruling will take from the judge?
It's hard to speculate. It depends on the judge's time and how long of an opinion he wants to write. Last time we had a hearing, I think it took 2 to 3 months. So I would guess somewhere in the 2 to 6 month range. But you never know. It could be faster, it could be longer. It just depends on his schedule.
Are there any other states that have seen the results that we anticipate and hope occur that, I mean, would be, I guess, precedent setting for this case?
There have been a few other cases that have won on this subject. One of them involved a teacher. So a teacher sued a school district over a policy like this, was being told that the teacher had to lie to parents about what was happening at school. And the court issued a preliminary injunction in that situation. There was another case involving a teacher who allegedly had a bunch of lessons about gender identity and told the first graders not to tell their parents about what the teacher was telling them during the school day.
Wow.
That case survived a motion to dismiss. So there's been some early wins in this area, but like I said, a lot of it is in the very early stages of the litigation, and so most of the cases haven't reached decision yet.
Well, I'm on the edge of my seat until this is decided. Luke Berg, thank you so much for all that you do on behalf of the good guys. I really sincerely appreciate it, from Wisconsin Institute for Law and Liberty. And you can go out to their website again, will-law.org, for more information. Luke, keep in touch and let me know as soon as you hear anything from the judge.
Thanks so much for having me on.